Hello, welcome to our next module. In this module, we'll be going over the different Supreme Court opinions. This also dovetails with your Supreme Court paper assignment. So the opinion of the court, this is the official ruling of the court. This becomes a part of our understanding of common law. So when it comes to the Supreme Court and the opinions, the other ones we'll be talking about in a minute, this is the one that really matters. All right, this is the one that we follow in terms of how they ruled, the prescriptive element of it, the standards, and so forth. Concurring opinions agree with the outcome or the ruling of the court, but that's kind of, to me, in quick and very layman's terms, the best way to think of it. So I always, try to explain in my classes that, it can very well be that you just have a justice who feels compelled to write their own opinion, even though they agree with the outcome of ruling of the court, or it could also be that they agree with the outcome, but they might disagree with the logic that actually gets to that ruling. All right. Dissenting opinion. A dissenting opinion just absolutely just out and out disagrees with the opinion of the court. Now, in the hierarchy of what we normally study, we usually think of the opinion of the court as most important when we study it, then the dissenting opinion. Why do we say the dissenting opinion as opposed to the concurring? The dissenting opinion usually has interest, in its purpose. A dissenting opinion has one of two purposes. One, either to lay the foundation for that ruling to be overturned later, or probably what is more likely with a dissenting opinion is that when you think of the whole framework of common law and an area of law, that might not affect that specific case, but may affect future cases that are kind of sort of similar when they come to the court and try to affect those rulings. All right. And then we also have in part opinions. This is where a justice concurs in part, dissents in part, and could be a little unfair for a second to say they're right in the fence, but seriously, an in part opinion, you see it once in a while. It is where you have a justice that agrees with part of the ruling and disagrees with part of the ruling. All right. Now, when it comes to the ways the Supreme Court rules, there are really two primary ways and a third by default. And I'm just going to go over this briefly. Prescriptive. The Supreme Court can be very prescriptive when it receives a case and it rules on it, outlines the standards and things like that. That's pretty much straightforward, makes walking around sense. Reverse and remand. This is where the Supreme Court, they get a case on appeal, they review it, make a ruling, but then they send it back to the lower court to hear again based on the guidance that they provide in their ruling. But when I'm talking about the ways in which the Supreme Court can rule, well, I do want to touch on prescriptive and reverse and remand. There's really another reason why I want to cover this. Denying appeal. All right. This is something that there's a lot of confusion on, and you hear this off and on even in the national media as they cover the Supreme Court. Well, yeah, they might say, well, the Supreme Court upheld something or struck down something, and you stay tuned and you hear, well, they just denied appeal. Well, when the Supreme Court denies appeal, well, as we said in a previous module, the Supreme Court only has so much bandwidth and can only hear so many cases in any given session. So when it denies appeal, it really isn't doing anything with it. They are not bound. It does not set precedent. It does not do anything because the Supreme Court hasn't even touched it. So let's say you and I were engaged in some sort of litigation, and then I lost at the Court of Appeals level. I appealed the Supreme Court. They denied my appeal. I'm just out of luck. Let's say the exact same case, exact same particulars went to the Supreme Court 10 years later. The Supreme Court is not bound to anything because they've never heard it before. There's no precedent there, right? So it's just they haven't touched it. So when the Supreme Court denies appeals, the lower court ruling stands by default. However, when that happens, the Supreme Court does not imply that they agree necessarily with that lower court ruling. All right. So just wanted to go through this in particular, the deny and appeal concept. With that, that's the end of this module, and we'll pick it up with the next one. Thank you.